This case management conference is in the matter of CFI 064-2022 before Her Excellency Justice Maha and Mheiri. The claimant is represented by Clyde & Co. Lead counsel is Mr. Mark Beswetherick. The defendant is represented by El Rashid and Partners. Lead counsel is Mr. Simon Isgar. Thank you, Your Excellency.
Thank you. Mr. Mark?
Good morning, Your Excellency. Good afternoon, Your Excellency. Could I just ask whether you've had any chance to look at any of the documents in advance, such as the case memorandum, just so I can save some time to brief on the background? Okay. I've had the benefit of conversation with Mr. Isgar, who appears for IPMR this morning. Just to point out that we are obviously acting for the insurer. Typically, the insurer would be the defendant to the claim, but because of the relief we're seeking in this claim being negative declarations, the roles are slightly reversed. So although we're the insurer, typically would be the defendant, I'm going first. But I have spoken to Mr. Isgar this morning to try and narrow some of the issues further. I would still like to spend some time, if I could, talking about the causes of action with your permission, because I think it goes to one of the issues that's still unresolved, but we've managed to agree most of the directions. I think the issues that still remain to be resolved are the governing law of the dispute, and we'll come back to that separately, but also the question of the expert evidence. And I appreciate the registry gave an indication that they thought a separate application would be made, but I think Mr. Isgar and I both agree that if possible, we would like to try and resolve that issue today, and to try and get leave as part of the general case management process for the experts that are required, rather than have to make separate applications in accordance with the overriding objective. So other than that, we have managed to discuss and agree most of the other issues. So some of the issues that are in the case management information sheets are now resolved. Would it be helpful if I just, if you know a bit about the background of the dispute, if I just talk through, as a reminder, just some of the main causes of action, just as context for why we say certain types of experts are necessary for us as insurers, as an insurance company, to be able to prove its case. Would that be helpful?
Mr. Mark, just for you to be aware, since I will not be hearing the trial for this claim, this application will go straight to the trial judge, and he's going to rule if he needs experts or not. So it's not a given right in the cases in the IFC. It's by application, and it will go straight to the trial judge. Just for you to be aware, even if you explain the process, I will also direct that this will go through application and to the trial judge. If you would like to deal with it before, after production, it can be an early application, but it has to be by application, and it has to be to the trial judge.
In that case, I won't waste time explaining the cause of action, because I think the only relevance for that was to the experts. As if that issue is not decided today, then thank you for that steer. Just to give you an indication in relation to the draft directions, then, if I could take you to Section B of the bundle, at tab 2, the agreed draft directions, just to bring you up to speed with what I discussed with Mr. Isgar this morning, and then perhaps if he disagrees with anything I say or not relaying the conversation properly, then he can comment as well. But just to bring you up to speed with the latest directions, because obviously that's something which we will no doubt like us to file after this hearing, regardless of the expert issues. So at page 57 of that tab, we have the draft directions that agree, and you'll see that there's a marked up version to reflect some last minute discussions. There's been some further discussions and a request from Mr. Isgar this morning for further extension of time. We haven't had time to take instructions on those, but we'll do so. But there is a proposal to potentially amend paragraph 1 to the 16th of December and paragraph 2 to the 23rd of December. But overall, that shouldn't disrupt the timetable, because paragraph 3 in the request to produce should be on the 3rd of January. So we will update the court on that, hopefully by the end of this week, and try to agree those between us. The proposal in the case management information sheet in relation to joint experts has now been dropped. And from my perspective, the only other point we wanted to raise for the court's attention, and again, it may be that this is an issue for the trial judge, is that we very much wish to see a trial in person rather than remote. And it may be that for a case of this estimated length between 5 and 8 days. That's what the court had in mind anyway, but just to put lay down a marker on that point as well. And we can come back to that if necessary when this comes back on the expert issues as well. But other than that, I think we are largely agreed on the directions. The other issue I mentioned, apart from experts, is the governing law issue. Now, that has now been added to the list of issues at the end of the case memo. So we agree that governing law is an issue that needs to be resolved. Mr. Iskar and I discussed this morning whether or not, without disrupting this current timetable as set out in the directions, there may be a way for us to narrow the issues and possibly try and resolve that as a preliminary issue. So we have agreed that we will do our best to discuss that early next week, and if either side intends to make an application to resolve the governing law issue, because we certainly agreed that it would potentially narrow down the issues and make the case management more efficient in terms of the expert evidence that's required, with some of the expert evidence falling away if it's UAE law, not DIFC law. So that's an ongoing process as well. We will write to the court, hopefully by the end of next week, to update them on that as well. But other than that, I think those were the only issues I wanted to raise in the absence of a debate about expert leave today. So I'll pass to Mr. Iskar to clarify anything else I misrepresented. Thank you.
Good afternoon, Your Excellency. If I may give leave to the court, I agree with what my learned friend has actually said. We've had an open discussion this afternoon to agree much of the timetable in those issues, and further instructions will need to be taken, of course. I will point out, as my learned friend has on the governing law, the choice of law is for us quite paramount, because obviously there are two conflicting laws, both onshore and the reference to the DIFC laws. This would narrow the issues down and save the parties costs. So I would sort of press on the court that we need to deal with that, and whether the court could give directions. But I would agree with my learned friends that we could try and resolve this by an application next week. Other than that, we are in agreement with the draft order, subject to taking further instructions from our clients. Sorry, there is another point that I should raise.
Yes.
Having taken instructions this morning, we do intend to call possibly two more witnesses, both of expert in terms of insurance, local underwriting, and in respect of metal refinery. We are at this time in discussions with those experts, but will in due course and as soon as possible provide those details to the court and the other side.
They will appear as witnesses or as experts?
They will both appear as expert witnesses, both on in terms of underwriting and on the metal refinery operational process.
No issues, but that has to go through application. And
yes,
if the trial judge sees the importance of the expert, then he will allow it.
Yes. Thank you, Your Excellency.
So as I understand, the only issue is the governing law, and you will update the registry by next week for us to either put a timetable in relation to the application, or if parties agree, then that can move forward as the agreed CMC order.
Yeah, we will circulate once we've taken instructions on paragraphs 1 and 2. We'll circulate an updated draft, hopefully before close of business tomorrow, and then we'll come back on the expert application and any preliminary issue in relation to governing law next week. I think that's, as I understand, how this is to be resolved.
Mr. Simon, do you want anything from the court other than these issues?
No, I'm in agreement with that. That seems a sensible way forward, Your Excellency.
Okay. Thank you for your time. We will be waiting for your update by next week.
Thank you, Your Excellency.
Thank you. Have a nice day.